Pirates, beware. The Supreme Court is trying to decide whether copyright holders have the rights to turn off your internet. The case is Cox versus Sony. Sony, the owner of various copyrights, is suing Cox Communications, an internet service provider, saying that their customers are using their internet to pirate Sony's copyrighted works. Sony argues that they notified Cox of this, and Cox did nothing, and now Sony is seeking upwards of $1 billion of damages. Cox argues that this kind of holding would be too drastic, and if ISPs were to be held liable for the infringing activities of their users, they would have to be really sensitive to infringement notices and have to cut off internet to their users a lot to avoid liability. The effects of this are even more far-reaching when you think about larger networks, like hospitals or universities. If one computer or one phone on that network was an infringer or a pirate, would the internet service provider have to cut off internet to the whole network? Sony argues that without any real incentive for ISPs to stop copyright infringement, then the copyright holder has no real recourse against even repeat pirates and infringers that they know about. SCOTUS held oral arguments for this case back in December, and they seem to have some pretty skeptical questions for both sides. We'll probably get the decision in the next few months, but until then, make sure to follow Gearhart Law for more intellectual property news.